In November 2024, Kevin, not his real name, was sentenced at Raymond Terrace Local Court after pleading guilty to 1 count of aggravated animal cruelty. It really happened. Now, a lot was said during sentencing considerations. Check out the media stories if you want to know who said what. I'm going to approach this a little different and compare Kevin's sentencing against the purposes of sentencing under the law, namely Section 3A of the Crime Sentencing Procedure Act 1999. And I've got a friend to help me. Big disclaimer, the law doesn't say do this, then that. It's not a list of steps and then you tick a box and voila! Rather, I think the magistrate is required to do a sort of balancing act, weighing up a lot of factors. And the purposes of sentencing may not be obvious, and they may be attempting multiple purposes at the same time. There's a lot of case law around sentencing which assists in understanding how the law is applied. Check out the law first and then read up on the cases if you're interested. Let's go to the purposes of sentencing and see if this makes more sense, right? The law says a court may, keyword may, not must, may impose a sentence for the following purposes. First, punishment. Second, deterrence. It can be specific deterrence to deter the offender or general deterrence to deter the community. Third, protect the community from the offender. Fourth is rehabilitation of the offender. Fifth, accountability of the offender. Six, denounce the conduct. And seven, recognise the harm done. So Kevin was sentenced to an intensive corrections order for 9 months with 100 hours of community service. Basically, it's a jail sentence to be served in the community. What are you doing, mate? The magistrate explained this offending was on the serious side. All intensive correction orders have the standard condition, which is must not reoffend, and the person is to be supervised. They can also have additional conditions like home detention, electronic monitoring, a curfew, rehab, or must not consume alcohol or drugs. Kevin's intensive correction order only has the standard condition plus the community service, meaning he isn't under house arrest or curfew. So let's discuss the sentence and the purposes under the Sentencing Act. First, punishment. In my opinion, being convicted, being supervised for 9 months, and the community service goes to the purpose of punishment. Of course, jail in the community sounds less of a punishment than jail in jail. However, it's not nothing. Reoffend and you can quickly be resentenced to complete the rest of the sentence in actual jail. That's what hangs over the person serving the sentence. Having a conviction on paper can impact on your life. Applying for jobs or travelling. Named publicly as having an aggravated animal cruelty conviction, I think may be much worse for some people. The person faces shame and could be ostracised in the community. Second is deterrence. The magistrate explained that specific deterrence was a factor in Kevin's sentence because he did not have a criminal record, meaning the sentence is meant to deter Kevin from reappearing at the New South Wales local court again. He is in his 60s and hasn't offended until now. In my opinion, the decision to give a custodial sentence rather than a community corrections order goes to deterring that individual. The magistrate explains this offending was on the serious side. The third purpose of the sentence is to protect the community from the offender. In this case, maybe it's the chickens that need protection. I think this purpose is tied with deterrence. Deterring an offender who's just done their first offence in 60 odd years by giving them a jail sentence goes to preventing reoffending, which goes to protecting the community from the offender. So that's punishment and deterrence, which I think Kevin's sentence has. Happy to hear your thoughts. It's okay to disagree. These are just my observations. Let's swap chickens and discuss the other purposes of sentencing in the next part.